Okay, the next case on the docket is Episcopal Children's Services, Inc. versus Department of Children and Families. And let me reset everything here. And I will once again assume 5 minutes for rebuttal from the appellant, unless you advise me otherwise. And with that, is it Mr. Wallace?
Your Honor, Alan Wolburn. Mr. Wallace is at the co-counsel table.
I notice Mr. Wallace spells his name wrong, but you may proceed, Mr. Wolburn.
Thank you, Your Honor. My name has been misspelled a lot of different ways, but Wallace is not one of them. Your Honor, I represent Episcopal Children's Services, Inc. We're the appellant in this case. And we are here on the appeal of the Department of Children and Family Services final order issuing Class 1 sanctions against Episcopal for a violation of the department's child care facility handbook. The sanction was issued under what's called the classification summary, where all of the violations are classified into 1, 2, and 3, with Class 1 being the highest violation. The question presented in this appeal is this: if an agency proposes to adopt rules that incorporate other materials that also include rules, can the agency adopt those materials and rules as rules without first publishing them for public comment in the Florida Administrative Register?
So can we talk a little bit first preliminarily about which rulemaking or rulemakings are at issue here? Can you, as I understand it, you're seeking to challenge both the 2019 rulemaking as an unadopted rule and the 2021. If this court were to agree with you as to the 2019 rulemaking, what effect would that have on your client? Was your client sanctioned under the 2019
They were sanctioned under 2021, but the rule that was in place that was initially adopted that we're talking about was adopted in 2019 when they readopted the classification summary in 2021. It was just a readoption of a rule that was adopted in 2019. When under the Florida Administrative Procedure Act, if a rule is determined to be improperly and not adopted according to the rules with the Florida Administrative Procedure Act, then you go back to the last properly adopted rule. And so that's why I'm going back, just in case, so that I don't have them coming back saying, well, if I had challenged just 2021, they'd say, oh, well, we're coming back to 2019. Well, I need to go back to 2017, because that's the last time, that's the rule that we would not have been sanctioned under. So the agency is going to argue that because the legislature delegated the adoption of rule-making procedures to the Department of State, the answer to this question is found in the Department of State's rules, not the Florida Administrative Procedure Act. The administrative law judge below agreed with that argument, and he erred in doing so. Because this question presents a pure legal issue that is controlled by the statutes, this court is going to consider those statutes on de novo review. And because this court interpret statutes applying the supremacy of text principles of statutory construction, Section 12054 of the Florida Administrative Procedure Act, and not any rules of the Department of State answer the question. Because there's no case law in point, you are limited to reading the statutes. No rules, nothing else, no cases. You have the statute. And you have the directive from Ham, from the Florida Supreme Court, that you have to adopt the textualist approach. So let's look at Section 12054, and it's titled Rulemaking. Subsection 1, titled General Provisions Applicable to All Rules Other than Emergency Rules. Subsection A, the very first subsection says, rulemaking is not a matter of agency discretion. Each agency statement defined as a rule by Section 12052 shall be adopted by the rulemaking procedure provided by this section as soon as reasonable and practicable. Your Honor, the parties stipulated that the classification summary is a rule. In fact, it's 32 pages of rules. Now, if we're moving on through 154, it's Section 154, 1, Romanette I-1. The legislature says a rule may incorporate materials by reference but only as the materials exist on the date the rule is adopted. For purposes of the rule, changes in the material are not effective unless the rule is amended to incorporate the changes. And in 1 Romanet I-4, the legislature says, a rule may not be amended by reference only. Amendments must set out the amended rule in full as the same manner as required by the state constitution for laws.
Let's talk about that for a second. One of the aspects of your challenge had to do with the non-functionality of the hyperlinks. Let's say that those hyperlinks had been functioning such that, you know, a user or a member of the public could have gone into the notice of proposed rulemaking and clicked on them and been able to view the full text of the classification summary or the proposed amended classification summary. Would that have fixed the publication issue, or is that necessary but not sufficient for compliance with the rulemaking?
No, I believe that would have sufficed, because I'm not going to quibble over whether the department can put rules within materials. That was the legislature didn't expressly say it, but I'm not going to quibble over that because it's convenience. We're in the internet society. I'm not suggesting that that you have to put in 100 pages of rules, which is what we're talking about here, within the Florida Administrative Register. A link would have sufficed. I am now signed up. Every time the Florida Department of Children and Family proposes to adopt a new rule, I'm signed up on email, and I get an email, and I see it, and I know where to go look. And right now, if I was to go look at this rule, if this was today, this happens, when I go look to that link, it goes nowhere. It's XXX, it's a link to nowhere. It is not a hyperlink. So then this fits in with the adoption procedures of subsection 3 of section 12054A, titled Notices. Prior to the adoption, amendment, or repeal of any rule other than an emergency rule, an agency, upon approval of the agency head, shall give notice of its intended action, setting forth a short, plain explanation of the purpose and effect of the proposed action, the full text of the proposed rule or amendment, and a summary thereof. And moving on to subsection 2 of that same subsection, the legislature says the notice shall be published in the Florida Administrative Register not less than 28 days prior to the intended action. The rule shall be available for inspection and copying by the public at the time of the publication of notice. This is clearly the legislative intent. It's clearly stated that the public has an opportunity to review proposed rules before they're adopted and have an opportunity to comment on them. There's only one way to interpret the mandates of section 12054. When an agency publishes a proposed rule that it intends to adopt, and that rule incorporates materials that an agency also intends to adopt as a rule, the full text of the proposed rule means one of two things: publishing all of the rules contained in the materials separately in the Florida Administrative Register, or publishing the proposed rule, as Your Honor suggests, in the Florida Administrative Register with an active hyperlink to the materials incorporated in the rule. And the undisputed record below shows that neither of those things happen. In this case, the parties stipulated the classification summary is material incorporated by reference into Rule 65C-22.010. The classification summary is a rule. DCF relied upon the classification summary to sanction Episcopal Children's Services for violating a provision of the Child Care Handbook, which is itself incorporated in a separate rule. Department of Children and Family did not publish the classification summary in the Florida Administrative Register prior to its adoption. And in 2019 and in 2021, when DCF published the amendments to Rule 65C-22.010, there was no hyperlink. As I said before, there was no hyperlink to the classification summary. Based on these stipulations, there's only one conclusion this court can reach. The classification summary was not adopted in accordance with a rulemaking procedure provided by Section 12054. And because the Department of Children and Family did not adopt the classification summary in accordance with the rulemaking procedure required by Section 12054, recall the words shall were in that statute. Those are mandatory words. There is no option. DCF, therefore, could not sanction Episcopal Children's Services by imposing a Class 1 sanction for violating the handbook that governs the operation of child care facility. And that's because Section 157E1 expressly states that, quote, an agency or an administrative law judge may not base agency action that determines the substantial interest of a party on an unadopted rule, close quote. For these reasons, the court should remand this case to the department and order the department to reverse its Class 1 violation sanction. And either I'll reserve my time or I'm here for questions.
All right.
Thank you, Your Honors.
Good morning, Your Honors. May it please the Court, my name is Andrew McGinley. I serve as the General Counsel for the Florida Department of Children and Families. I'm here today asking the Court to uphold the underlying order issued by the Administrative Law Judge in this case. I think Section 12054 makes clear that the Department is entitled to adopt adopt materials incorporated by reference. The language is specifically in there. 12054 parens 1I3 specifically says that material may not be incorporated by reference unless the material has been submitted in the prescribed electronic format to the Department of State, and the full text of the material can be made available for free public access.
So as I understand it, I don't understand the other side to be disputing that the department followed the requirements for incorporation by reference. What your friends on the other side are saying is that the material at issue here also comprised a rule, and there is a separate requirement for the adoption procedures for rules. And I guess that a premise of their argument is that it is possible to comply with both, and that both adoption requirements apply when material constitutes both a rule and material incorporated by reference. So can you explain to us, just as a statutory interpretation matter, why either A, compliance with both sets of requirements is not possible, or B, why compliance with both requirements is not necessary?
Certainly. Well, first and foremost, my friends on the other side, their position asks the Court to ignore 1I6, which states that the Department of State may adopt by rule requirements for incorporating materials pursuant to this paragraph. And so there is specific rulemaking authority for the Department of State, which is not the Department of Children and Families. And within that, the Department of State assigns the hyperlink. The Department of State is the owner of the...
Now, that authority is the authority to promulgate rules for meeting the requirements of incorporation by reference. Does the Department of State also have authority to promulgate rules regarding the requirements for notices of rulemakings, of rules, for the procedures required to adopt rules?
Well, I think to answer your question, really what we're looking at is a rule challenge by proxy to the Department of State's Administrative Code Rule 1-1.013, because within the Department of State's rule, it addresses that any ordinance, standard, specification, guideline, manual, handbook, or other similar material that meets the definition of rule provided in Section 120-5216 may be incorporated by reference. And so what they're actually asking the Court to do is to find that the Department of State's rule describing what a material incorporated by reference is invalid.
Does that rule, though, purport to dispense with the statutory requirements for adopting rules, or does it instead outline only the requirements for incorporating material by reference, meaning that, whatever other legal requirements might apply, and we're not going to speak to that through this rule, we are going to define what the requirements for incorporation by reference entail, and here are those requirements? Right? Why do we have to read that rule to purport to dispense with the separate statutory scheme for outlining the requirements for adoption of rules.
Sure. I don't necessarily think that they are exclusive, and keep in mind that my friends would like the classification summary or the handbook to be considered a separate rule. And were it to be a totally separate rule outside maybe the single subject requirement or a standalone rule, then certainly you couldn't incorporate that in this manner. But the fact is that the Department of State has used its authority under 120.54 to define how they are going to accept materials incorporated by reference. And so really I think this boils down to, are we calling the handbook that greater defines exactly what is stated within the department's rule, is that a separate standalone rule that is required to be published 28 days to go through that? Or is it something that is permissible to be incorporated by reference? Because if it's to be incorporated by reference, then certainly not only does it not need to be published 28 days before, but it couldn't be because the Department of Children and Families doesn't publish, right? We submit to the Department of State to publish. And so if it's its own that would require a separate publication, then we would have to go through, for just the handbook, all of the requirements in 120 to do that, right?
So can I ask you a hypo? What, under your reading of the relevant statutes and Department of State rules, would prevent a state agency from adopting, a rulemaking procedure that proceeds along the following manner? The notice of proposed rulemaking says, the department proposes to adopt the rule specified in Exhibit A for the policy reasons described in Exhibit A, full stop, the end. Exhibit A has a hyperlink that is non-functioning, but which was supposed to link to the material which describes the entire, change to the regulatory text and the reasons therefore, and the public is not able to access that hyperlink, throughout the entire course of the proposed rulemaking. That material is then transmitted to the Department of State pursuant to the procedures for incorporating material by reference. Has the department successfully promulgated a rule pursuant to the required rulemaking procedures? Essentially, can the department say, full stop, see Exhibit A, and have a little squib, notice of proposed rulemaking, and would that satisfy the statute? And if not, why not?
No, in fact, I think that would violate 120.54 1I4 that states that the rule may not be amended by reference only. And I think that would probably be, in your scenario there, that would probably violate that in the sense that we simply say, we're amending this rule, no other information except through this additional hyperlink, quote unquote, material by reference, right? And so I think that the statute in and of itself would prohibit that, which is why I think the administrative law judge, Van Lanningham, the example that was given in a previous case, certainly, Judge Van Lanningham sees a lot of these cases, but that was more of a, I would suggest an off-the-cuff hypothetical that realistically would never happen because I think it would violate sub 1I4 in the sense that we're not permitted to only modify by reference, and that's not the modify or amend through incorporation by reference, and that's not the allegation here, right? The underlying, the actual rule was amended, and the scheme of punishments or violations were amended by reference.
Right, but you've conceded, I understand the department has conceded that the classification summary itself constitutes a rule as defined in the statute, right? So how was that classification summary amended?
I believe that it was amended in consultation with the amendment of a rule. The classification summary is a rule as defined by the statute, right? I think there's no way around that. I think it would be false to say that it doesn't meet the definition, and so, but it was amended along with the rule to which it relates.
Sure,
right?
But as to the classification,
the classification itself,
it amended by reference only here?
it would be that portion of the rule, yes, would be amended by reference in that manner. And one thing I want to touch on actually while we're talking about this is that appellants would like to revert basically back to the 2017 scheme because it would make their violation a Class 2, not a Class 1. But there's no evidence in the record that suggests that that schedule was done in any manner different than this. So the ultimate argument at issue is they want to go back to 2017 because it is more suitable. It's a Class 2 rather than a Class 1. But there is no evidence for this court to consider that suggests how the 2017 schedule was.
But don't they get to pick which rulemakings they want to challenge and which they don't? I mean, I understand the point,
Yeah.
right, which there may be reasons why something could be challengeable, but nonetheless not challenged.
Sure.
But, I mean, that's sort of their choice in defining their suit, right?
Absolutely, yeah. And I mean, ultimately, as I said before, this really is a challenge, as I see it, to the Department of State's rule by proxy. When you look at the requirements, we are to submit our rule 28 days beforehand. We are to submit the rule, and I think this is really, really informative. In 12054-3A2 and A4, it expressly sets out that the rule, the notice shall not be published in the Florida Administrative Register not less than 28 days prior to the intended action. The proposed rule shall be available. 4 then says the adopting agency shall file with JAPC, the committee, at least 21 days prior to the proposed adoption date, a copy of the rule it proposes to adopt and any material incorporated by reference. And so I think that the statutory scheme specifically contemplates materials incorporated by reference that has to go at a certain point through the rules committee that is published, that is available. And so I think that it's a timing issue more than it is a notice issue, right? Because these rules are out there, they have to be publicly available. The materials incorporated by reference have to be publicly available. But when you consider that the department has control over this, the Department of Children and Families has control over this. The Department of Children and Families does not have control over when the Department of State provides the hyperlink that would then go into the Department of Children and Families rule as published on the Department of State's website. So I think the burden or the ask is that we, as the Department of Children and Families, should somehow have an active hyperlink that is outside of our control at the time that we are proposing rulemaking, at the time we are publishing the initial rule, which we have control over that. We do not have control over the hyperlink, which is why the Department of State has set out rules as to when they would provide that. And I believe it's no less than 3 days is their decision. But again, I think you have an onus problem with reading the statute the way that the appellants would ask this court to review it. It basically would put a burden on or an onus on the department of which we don't have any control. So ultimately, I mean, I think 12054 specifically prescribes that we can incorporate things by reference, which of course there's no dispute, right? The issue here is what exactly can be incorporated by reference. It also permits the Department of State to adopt by rule the requirements for incorporating materials to this paragraph, and we relied on this per se valid rule that is not challenged. The Department of State's rule 1-1.013. And so we are relying on a different agency's rule to do this, and really, if that's not the case, then I think that's probably the rule that may be better addressed and presented to this court, which we, as the Department of Children and Families, cannot do. So we are relying on a per se valid rule that is not challenged here.
Is there a line drawing problem in your argument about the proportion of a rule that can be amended solely by incorporation by reference, right? So the classification summary under I may not be understanding totally accurately, so please correct me if I'm wrong, but the classification summary forms a part, in your view, of the rule that was to be amended, but not in total, right? So that, by complying with, only the requirements for incorporation by reference, it's not amending the rule only by reference because there's some other portion of the rule that was noticed properly. Is that essentially what I hear?
That's absolutely correct.
Okay.
There wasn't...
So let's say that the classification summary, maybe in this instance it's only like 2% of the rule. But what if it's like 80, right? What if the proposed rulemaking had mostly to do with the classification of offenses, but had some ancillary matters, and those ancillary matters were noticed appropriately within 28 days, but the classification summary was noticed in the same way that it was here. You know, I mean, would you still be telling us that, well, we've noticed the rule properly because, you know, even though the classification summary is maybe 80% of the policy content that's being changed here, it's still not the total, and therefore, because we've noticed the other 20%, it all comes out in the wash?
Sure.
Help me walk through that.
Absolutely. I think my friends did an excellent job of pointing out that there is no real case law or guide star on this issue. And I think I want to be careful about using percentages because, I mean, we're talking about volume, are we talking about impact, right? There's a lot of ways we can talk about percentage. So ultimately, the rule that went through rulemaking allows the department to provide this penalty scheme. And then you have this material incorporated by reference that outlines the scheme. And so I think the question is, if the rule is, hey, we're going to put forward a scheme of punishment, we want our penalties, I guess, you can provide comment on that, you know, ways you might want to see this, but it really is just almost an equivalent, like a rate sheet, right, that is attached. And while that may be the bulk of the text of quote unquote this rule, I don't think that's the case in this case, which is why I don't think this is a good case to draw like a poll star, a guide, or the outer parameters of where, you know, what is permissible to incorporate by reference or not. I think it's the underlying, what was amended through the actual publishing, or what was, and versus what was incorporated by reference here, is on the one side, the department's ability to do this, right? And then on the other side, you have what I would equate to basically a rate sheet. Hey, here's what we're calling a class 1, here's what we're calling a class 2, and, you know, giving notice to somebody who is applying, or a licensee, as in this case, you know, what the violation would be, but it doesn't give the authority, it's not giving the inherent authority to do that. And so I think that's probably, in this case, maybe the best we're going to get out of this factual example, which is why I don't think this is necessarily the best case to draw either that bright line or the outer parameters based on the hypothetical or the question that you posited. But ultimately, I mean, I think that the rule was correctly promulgated, both in 2019 and in 2021. I think that the material that was incorporated by reference is informative. It's a schedule. It is, as the Department of State called it, a specification, guideline, manual, handbook, or other similar material that may meet the definition of rule, but can still be incorporated by reference. At no time was the entire bulk of the rule shoved into a hyperlink that then wasn't provided to the public or to interested people.
You would concede, it sounds like, if the rulemaking here had simply been a change in the classification summary with nothing else, and if the classification summary had been purported to have been amended through this rulemaking procedure, that would not have sufficed. It's the fact that it's part and parcel of a much broader rulemaking that was noticed. That's what saves, in your view, the classification summary.
I don't know that I'm necessarily conceding that. I think that's just not what occurred here, and so I'm not gonna, you know, on behalf of the state of Florida, concede that that is the case. I think as the case that is presented to the court, the amendment was done correctly, and in part of that was in 2019 an update to the classification schedule that was then brought forward with other modifications, I believe both to the handbook and to the rule, in 2021. And so while this specific penalty scheme may not have been amended in 2021, my understanding is both the rule and other parts of the handbook were, which I think goes to their argument why it should be 2019, but I don't think that's the case. And so I don't necessarily want to concede that across the board as a bright line rule, changes to materials incorporated by reference like that, because again, I only speak for the Department of Children and Families, and I don't want to bind, for example, DBPR having no experience in their materials incorporated by reference, bind them to that. But as to the rule that is presented before the court that was at issue here, I don't think we even have to get to that inquiry, because that just simply wasn't the case. I'm almost out of time, so if there's no more questions, I would simply finish with, we would ask that the court uphold the administrative law judge's interpretation of the text in in both 12054 as well as applying the valid administrative rule 1-1.013. Thank you.
Yes, Your Honor, I will, Your Honors, I will try to be brief.
Counsel, could I ask a quick question that may deter you a little bit? Just this Rule 1-1.013, can you talk to me about that a little bit and maybe just walk me through why you think it either doesn't apply here or incorrect?
Well, it doesn't apply because it's not a statute. That's number one. Number two, all the rule says is that you'll have to provide the materials at least 3 days before they're adopted as a rule. The last I checked, 28 days is more than at least 3 days. There's nothing in that rule that said the agency cannot submit those materials to the Department of State before 28 days. In fact, they submitted one of these rules 25 days before. They submitted the materials to the Department of State 25 days before they adopted the rule. They could have done it another 4 days too. Nothing stopped them from doing this. The Department of State doesn't say you shall submit it on the third day before the rule is adopted. Second, we are not challenging that rule. It appears one place in the petition, and it's, maybe I pulled out the wrong thing, but I used it, I quoted, or I cited Rule 1-1.013 as support for the proposition that the classification summary had to be adopted in accordance with Section 12054. That's what the rule says. And if for some reason the Department of State's rules somehow precluded the agency from putting these materials incorporated by reference into the Rule 65C 22.010, then by hook or by crook, they needed to do it. They had to go back the old way. You went back to 1990, and you put it all in. There was nothing in the rules, and there's nothing in the statutes that stopped them from following the big statute, Section 12054, rulemaking. We did not challenge, we are not challenging at all the Department of State's rules. Judge Pratt, you asked the question about, well, what happens if the Department of State, can you just, say, well, all the rules are contained here? Well, that's exactly what happens with the handbook. I'm going to read you from 65C 22.001B6. Child care standards. Child care programs must follow the standards found in the, quote, child care facility handbook, close quote. Insert date, scratched out October 17th, incorporated by herein by reference. The handbook may be obtained from the following department's website at www.myfamilies.com or from the following link that again ends with XXX. Nothing.
So the
All
department,
of the rules, it's 80 pages of rules, I'm sorry, Your Honor.
sounds like the department's response to that is, well, the rule that's being amended is everything set forth in the rulemaking. And it sounds like your view is different. In your view, the rule is the particular subsection of a Florida Administrative Code, and there may be multiple rules that are amended in a single rulemaking. Is that right? Is that what you understand the beef to be, and why are you right and why is he wrong?
Because a rule is an agency statement. Let me go get my statute. Comes down to what is a rule. The rule is defined in Section 12052 as A rule means each agency statement of general applicability that implements, interprets, or prescribes law or policy, or describes the procedure or practice requirements of an agency, and includes any form which imposes any requirement or solicits any information not specifically required by statute or by an existing rule. The term also includes the amendment or repeal of a rule. It is each agency statement, and there are 35 pages of agency statements within the classification summary. In the handbook, there are 83 pages of agency statements. The rule is not just what you call a number. The rule is something. It is an agency statement.
And what
All
do
of
we
the
make,
agency
counsel,
statements.
of the use of the singular in section 120.54 outlining the requirements for promulgation of rules, where it says, shall give notice if it's in action, the full text of the proposed rule or amendment and a summary thereof. Focusing on the singular, can you walk me through that real quick?
Sure, the full text of the proposed rule is the full text of the agency statement. And the agency statement in this case is the entire classification summary. I mean, there's boxes in there, and each one of those boxes when the classification summary is its own agency rule. Because we talked about the classification summary being a rule, it is a set of rules. I don't know, did that answer the question?
Sounds like we're talking about Russian nesting dolls. You know, there's a rule within a rule within a rule. I mean, at what point?
It's a rule. They're all rules. It's a subsection of a rule. Statutes have subsections. This is no different than being a subsection of a statute. These are all the rules. Every time, it could be a single statement that was incorporated by reference, and that statement would be a rule, and it would have to be published prior to its adoption. The legislative intent is abundantly clear. I don't practice a lot of administrative procedure. Maybe that's why I saw this, but I did take Florida Administrative Procedure at FSU, and Judge Seidenfeld, one of the first things you learned is all rules have to be published before they're adopted. This is, if you can just say that the rule is 65C-22.010, go see the handbook incorporated by reference. It is beyond me to think that the legislature ever intended that agencies could adopt rules like that. The incorporation by reference is a convenience factor that was added after the internet. Before the internet, the classification summary would have been published in full in the Florida Administrative Register prior to its adoption.
Can you give me an example, and I understand with your immediate past statement about not being as familiar with administrative procedure issues, this may be an unfair question, but I'm going to ask it anyway. Can you give me an example of material incorporated by reference in an agency rule of which you're aware that does not itself comprise a rule, such that the relevant agency or department could achieve its incorporation by reference without being subject to the rulemaking requirements in 120.54?
Sure. A map. I think it's cited in there in the Department of State rules. A form that your name, your address, the rule you're challenging, and that if that's the form that you're talking about. It could be any number of forms that don't have in themselves rules. But a map, I think, is the best example. The St. Johns River Water Management District could very easily have a rule that says, see the map at link X for the area that's covered by the St. Johns River Water Management District. That's not a rule. And it can be incorporated by reference. And if they didn't, and if they were, I guess if they were redrawing that map while the adoption process is going forward, and they weren't telling the public about it, well, I guess that would be a rule. So maybe map in that instance is a bad example. But your public certainly would want to know what areas the St. Johns River Water Management District is going to cover, and that should be published before the rule is adopted. Every rule has to be published before it's adopted. Every agency statement of general applicability has to be published before it's adopted. I ask the court to reverse and remand.
Thank you, counsel. Well argued. And Mr. Wallace, I just note, you didn't have wrong spelling, it's the alternate spelling of Wallace, so.
Thank you, Your Honor. I didn't catch the joke.
And we're in recess.
Rise.